There, I'm ready. Are we missing one?
No, sir. It just,
What's that?
it's a little wide right here.
But there's usually something in between each one. Yeah. I think it's usually there. I could be wrong.
Might be right. One of the five. And then yours.
Three, 4, 5. Can you speak one right now?
Yeah.
Hey, could you hear this bell if I mess it or just show a red light? That little thing to cue the marshal at the record come in?
Accused to the marshal. Go on
Okay.
here.
Make sure my butt works.
All right, go ahead, close the bank.
Hmm.
Go ahead, close the bank for the marshal.
Maybe that's your setting?
I guess, I don't know.
So.
If you want to switch, I'm happy to.
So.
Mhm.
But it was the hybrid argument. I don't know, I don't know if you knew this was went to the hybrid, where they had some people on the Zoom, some people in the corner. They had a big screen that said, so then they had set up, I was the first virtual admin. So I had a lay person argument, and they called me. Immediately. So I can't hear what he's saying. So it was like,
So you're just going like, can you hear me?
no, I'll tell you what. I was like, what did you do? No, I'll tell you. Well,
So at least we don't have to worry about that. Do you mind if I go ahead and position this height-wise?
yeah, you want up or down?
I think maybe just a little further up. Check, check, 1, 2.
Morning. You familiar with the light?
Yellow means 1 minute left, right?
No, because you don't have any rebuttal
Oh,
time.
yeah, so it'll
It'll
just
go
like
from
stop.
green to red. You familiar with the light? Well, you have 15
Go straight,
minutes.
but the timer, we'll see the time.
Yes. And this is adjustable if you need to.
I think you'll probably need to adjust it after me, since I'm so much shorter than you.
That's all. Keep him in trouble later.
All rise. Hear ye, hear ye, hear ye. Supreme Court of Florida is now in session. All who have cause to plead, draw near. Give attention, it shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on today's docket is In Re Amendments to Florida Rule of Civil Procedure 1.442. Counsel.
Thank you, Chief Justice, and good morning, Your Honors. May it please this court, my name is Bailey Howard, and I represent the Florida Justice Association in these proceedings. Your Honors, at the heart of the FJA's comment is a framework we propose this court should use to evaluate any proposed amendment to Rule 1.442. And that framework ultimately derives from the Florida Constitution, and it consists of three questions that are pretty straightforward. The first is whether the amendment is substantive or procedural in nature. The second is to a degree intertwined with the first, and it asks whether the proposed amendment is consistent with all of the relevant statutes, which are more than just Section 768.79, although that's the one most frequently referred to under the proposal for settlement mechanism. There are, in fact, other statutes that use proposals for settlement, and the rule should effectuate the purpose and function of those statutes also. The third question is whether it makes good sense in a public policy perspective, to make the proposed amendment in question, whether it would further the purposes of the proposal for settlement mechanism, which are to encourage settlement and to reduce litigation. And the FJA's position here, Your Honors, is basically that if we take that framework and we apply it to the proposed amendments, the logical result is what the FJA advocates in its comment, that there are some things that are inconsistent with statutes and need minor tweaks to resolve them. There are some things that are substantive and should not be in the rule because they have the potential to create confusion or to vary from the substance of the statutes that are on point. And there are some things that just don't make sense from the perspective of furthering the purposes of the proposal for settlement mechanism. So to begin with, the proposed amendments to subdivision C2C and D are things that the FJA submits this court respectfully should approve with minor modifications. They exclude non-monetary conditions of the proposals for settlement except for a voluntary dismissal with prejudice. And the minor tweak that needs to happen here, as the FJA sees things, is that this is inconsistent with some of the statutes. There are statutes that specifically permit non-monetary conditions to be used in proposals for settlement. And in particular, that's section 70.001, subsection 4C. It specifically contemplates certain non-monetary conditions, and Rule 1.442 applies to that statute, so that tweak is necessary. Furthermore, it's important to note that although the proposals for settlement, you can't demand something you couldn't get in the lawsuit. Something that FJA members do consider important is that payment as a condition of settlement is a monetary condition for a couple of reasons. It's one, inextricably intertwined with a monetary condition. The existence of a amount in the proposal for settlement really only exists so that you can ultimately be paid that amount. And moreover, it is something that the party could receive in the litigation because the opposing party could confess judgment by just paying the amount demanded. And then the party would be entitled to the entry of a judgment on their behalf as sort of an administrative matter for the court to close out the case. So that's a factor that this court should consider when it's determining whether to make those amendments to the rule.
Doesn't that sort of effectuate an end run, though, around judgment enforcement proceedings and constitutionally permissible defenses against enforcement of a judgment? And it is one thing to stipulate that a money judgment is in order, right? And that's why 768.79D requires that we state it's the total amount of a judgment. But there may be extraterritoriality defenses and other defenses to the enforcement of a judgment. Don't you agree?
I do agree with Your Honor. There would be extraterritoriality defenses and so forth, but by confessing judgment, a party abandons those and waives them. I mean, confession of judgment was originally an extraterritorial issue. It was a way to get a judgment in another jurisdiction enforced in your jurisdiction. And so in that sense, it's still something that would be available in the action. And so those defenses would still be available, but the act of confessing a judgment puts them beyond your reach. So I don't think it would raise the constitutional issues Your Honor brings up in the context of an amendment to Rule 1.442. But the real heart of the comment is to make sure that there's consistency with the statutes. And that should be the court's first concern here, is to be consistent with the applicable statutes. It's also important to remember there that the parties can negotiate their own settlements outside the context of the proposal for settlement mechanism. And so if there are conditions the parties want, such as releases or confidentiality provisions, the parties could still negotiate for and obtain those outside the context of Rule 1.442 and the proposal for settlement mechanism. So this court's amendments, if it did not include non-monetary conditions, except to the extent specifically permitted by statute, wouldn't place those conditions beyond parties' reach when they're important to parties. The second set of amendments, or proposed amendments, that the FJA has matters to comment on, I suppose, are the subdivisions section C2B, E, and F, which involve the incorporation of the attorney's fees, costs, and interest into the amount of the proposal for settlement. And here again, we have some conflict with statutes, because some statutes say you can't include things of this nature, some statutes say you must include them, and some statutes say you can if you want to. And so there's an issue of statutory consistency there. There's also, as the Civil Procedure Rules Committee points out in its comment, there's a potential inconsistency with the language of section 768.79, because 768.79 says the proposal for settlement will be construed to include all damages that would be available in a judgment in the action. But that's in subsection 768.79, subsection 2. This court's decision in White versus Steak and Ale in CCM, as the Civil Procedure Committee correctly points out, interpreted subsection 6 of that statute, but not subsection 2. So the substance of the law is not necessarily in alignment with what the rules is, the proposed amendment to the rule would provide. But the omitted case canon is really the thing that's on point there, because the statute does not provide for anything beyond the damages. At least the statute on point that I'm talking about here, section 768.79, doesn't provide for anything beyond the damages to be in the proposal for settlement. Other statutes do things differently, and so that's something that this court would have to note as it proceeds with any amendments.
So your position would be that with 768.79, because it does provide for damages as the offer and not attorney's fees and costs, that if we had a rule that required inclusion of attorney's fees and costs, it would be substantively inconsistent with the statute?
Yes, Your Honor. That's a fair statement of what I'm saying.
It would also be very problematic, which you point out in your brief, correct?
Yes, Your Honor, it would.
It would be very difficult to put together an offer that it'd be easy to anticipate these are the likely damages, we've had discovery, we know what those are. This is our likelihood of success, this is what we think a jury would do, but it'd be really hard, I would think, to anticipate the attorney's fees another side might get, and those kind of things. Would you agree with that?
Yes, Your Honor.
So it makes it unworkable as well.
Yes, Your Honor. It would
Go ahead.
I'm sorry.
Go ahead.
Thank you, Your Honor. It would be difficult not just to anticipate those things, but then to litigate them afterwards. I mean, as we explained in the comment, when you go to determine whether the proposal for settlement should be enforced and whether you're entitled to attorney's fees under it, you effectively have to have a mini trial about the damages you would have gotten anyway. And so at that point, what's the point of settling if you're going to have a mini trial about it anyway? And the same concern arises in the third set of amendments that the FJA would like to comment upon, and that's the proposed amendments to the joint proposals for settlement in subdivision C5. And there, the proposed amendment would keep a settling party in the litigation, and that's I'll rest on the comment otherwise, except to the extent this court has questions about it, but that's the thing that I would really like to emphasize to this court, is that the proposed amendments to subsection C5 keep a party that was willing to settle in the litigation. They force them to stay in it, and that party would then have to proceed. and litigate the case in a sort of tautological statement, if you'll excuse me for making one. So this doesn't encourage settlement. In fact, it prevents settlement, because now that this party that was willing to settle is kept in the case. And it's unclear from the rule what would happen if that party then settles the following day in a non-Rule 1.442, non-PFS related settlement on those same terms, because now the parties know that those were acceptable terms for this party to settle on. And if they then settle on that basis, what happens? The rule doesn't answer this question.
My question, and I think Justice Lawson, because he covered it pretty well, and I think you covered on the attorney's fees part of it. The thing about these offers, the whole history of it, I was in practice in the mid-'80s when we started these offers of judgment things. And every year, either the legislature or we meddle with it. And so you have all these different statutes, different rules, and you have to look at the year when the accident happened. Kind of the same thing as stacking uninsured motorist insurance. Every year, one year you have stacking, the next year you don't have stacking, and it goes on and on and on. We keep meddling with it. And a lot of lawyers malpractice because they may have settled a case when they may have had stacking and didn't look at the statute. Same thing here with this offers of judgment. I remember trying a case in Broward County in the beginning of this offers of judgment thing where you could accept the judgment in trial. In fact, we accepted it after selecting a jury, and it wasn't one to our liking. So we took it. But now you do it within 60 days or within 30 days. It was 10 days for a while. You got to look at the year when it was enacted and then the rule was enacted. It's all very confusing. And for something that was devised to promote settlement, so something that was devised to take these cases out of the judicial system and get them settled and moving on, this is just adding more complications, it seems to me, to an already confusing area of the law. The attorney's fees part of it is mind-blowing to anyone who has practiced in this area as to we know what's going to happen there. Case is not going to settle. You're not going to promote anything. And the last one you mentioned about joint parties, I mean, you're always going to have one party who happens to be in privity of whatever happened with some product. It's a small player who is not going to want to settle. And that will stop settlement. So I don't know how this promotes anything. And I would just say, leave what's broken alone. We'll figure out how to put the pieces back together. We get that Gorilla Glue, we'll do something, and leave us alone. Let's move on. That's my position.
Well, Your Honor, in that spirit, unless this court has any further questions, I'll yield the remainder of my time to the court.
I do, actually.
Yes, Your Honor.
So I understand your point that with the subsection that adds attorney's fees and costs as something that needs to be included is inconsistent with the statute, so that would be inappropriate because it would change substantive law. So we're there. On the joint proposal, your position is that the statute uses the singular party and that precludes a joint proposal. What about the statute that says that the singular includes the plural and interpreting all the statutes and the plural includes the singular as the context permits? Wouldn't that allow for that word at least to be a plural, parties?
Yes, Your Honor, except that what Section 1.01 says is that the singular includes the plural and the plural includes the singular where it makes sense for it to do so. Mm-hmm. And in this context, it doesn't really make sense for it to do so. That reading doesn't flow naturally from the text of certainly Section 768.79 and potentially from the other proposal for settlement mechanism statutes as well, because of all of the problems this court has articulated and that our comment articulates, and concerns that I think all of the commenters share in their comments with the joint proposals. There is a potential for gamesmanship. There's a potential for confusion, and there's a lot of.
Let me just ask you about that, because it seems to me like there's some types of litigation, some situations where a joint proposal would be appropriate and would preclude gamesmanship, and somewhere it would be inappropriate in that it would just allow for gamesmanship. And the other is true. There's somewhere individual proposals might be subject to gamesmanship, and some types of suits where, and they're outlined in the brief. So the question is, would it be inconsistent with substantive law, which just is very general, to say if some smart people like y'all could figure out in this type of lawsuit a joint proposal is appropriate, and this type a single is appropriate, and then have that laid out by rule in terms of the procedure by which we'll take this very general statute and make it applicable to various types of lawsuits. I mean, because to me that seems like the kind of thing a procedural rule should do. It's not inconsistent with the statute at all. It implements it with the procedure. Do you view that, something like that, would you view that as substantive or procedural? That would be the question.
Your Honor, I would view that as a substantive matter because of the way, at least that Section 768.79 arranges these matters. Because it doesn't flow naturally from the statute. It's not an implication of the way that Section 768.79 works. 768.79, Chief Justice, I see I'm out of time.
You can keep going.
Thank you, Chief Justice. So the way Section 768.79 is supposed to work is to be a quick, simple, up-down settlement offer. And there are cases, the FJA certainly couldn't dispute, that there are cases where these joint settlement offers might be useful. And as Your Honor pointed out, we do discuss those in the comments. But to the extent it would be useful in a case, that's something that would be more appropriate for non-PFS settlement negotiations between the parties that a PFS could certainly spark and could certainly encourage the parties to embark on. But it's, per the omitted case canon, it's something the statute just does not consider. It's a void in the statute, and so it's neither a permission nor a restriction. It's just not there. And this court should not vary from the substance of statutes. And if there are no further questions, thank you very much, Your Honors.
Thank you.
Good morning, Chief Justice. May it please the court. I suppose I have 15 minutes to try to explain why we should fix a broken system, and I'll certainly do my part. As the chair of the Civil Procedure Rules Committee, we consider a lot of proposals that are provided to us from lower courts and practitioners and lawyers and judges or internally. This one came to us from this court. We did consider it, and I want to point out, this was in our comment, this is an important fact for this court to consider. This was a fairly unanimous committee vote on the comment that the Civil Rules Committee provided, which is not typical. Certainly in the last couple of years, there are very spirited debates because these rules do affect practice areas, practitioners, and litigants differently. There's no question that Rule 1.442, if applied in its current form or as the proposal seeks to apply it, will have result outcome differences for different groups. Notwithstanding, our committee, a very broad, diverse group of lawyers and judges were on board with the comment we provided. And that comment strived to really do one thing, try to make this rule. It is a broken rule. It's an awkward rule. There's issues. There's always going to be gamesmanship, right? We can't write a rule. We've tried to eliminate all games. We try to write the best rule we can. And so the comments that we provided really strive to give the court some guidance as to how best to accomplish the purpose of the statute, 768-79, and that is force settlements early. Settlements of cases that should settle, that are clogging the dockets of our courts, that are overcrowded. There was a comment and some discussion a few moments ago about you can always step outside of this procedure and just settle a case. That's true, but this is a carrot and stick function that conversation, the other conversation, the normal settlement conversation doesn't have.
Well, how me on the attorney's fees issue that Justice Lawson and I were talking about earlier, how does that help settle cases? If anything, I would think it would stop it. I guess in a personal injury setting, you have your standard contract before filing suit. It's what, 33 1/3% fee?
That's what I understand, roughly. Yeah.
Once suit is filed, is what, 40%? Plus
I think
cost?
they're all individual. I think they can, I don't do personal plaintiff's injury,
Okay.
but I understand that
I
is
assume
right.
that to be the case, just for the purpose of the question, plus costs after that, and that's obviously not determinable. So client, you settle the case for $100,000. The client, if case is in suit, lawyer's entitled to 40%. So now we know the client's going to get, what, 60%, $60,000 less cost. So that's already kind of built in. When you start other cases where we go by hourly fees and things like that, that's when it gets really complicated. And those cases are usually determined collaterally later on in a separate hearing, where a judge has to make factual findings as to, whether the fees were reasonable and necessary and that kind of thing. How does adding that in there, why would a lawyer settle a case when his fee may not be anywhere near what it may be if we had a hearing later on?
I understand the question, and let me see if I can answer it this way. In the context of those conversations, I would just say in practice, there's typically a conversation that goes on in addition to just general experience. You're in the pretrial motion stage. The case has been litigated for 4 months. Most lawyers that practice in a particular area should have a good general sense of how much time has been spent on the case and how much fees are reasonable. And I would just say from personal experience, that conversation typically happens in that normal settlement conversation context. The rule that whether it's a fees included proposal or a no fees proposal, as the Civil Rules Committee suggests should remain in the rule, could account for that. Right? The offeror can make it a no fees proposal, and then they leave the offeree to taking that offer and splitting up whatever that contingency fee award or amount would be with their lawyer. They can resolve that later, or they can make it a fee award and explain, I'm offering plaintiff, your claim is worth $10,000. I'm going to offer you $15,000 or $10,000, and it's also going to include fees. I don't know that there's a requirement in the statute that a fee proposal that includes an offer for fees is only permissible if there's an entitlement to fees. An average personal injury case, there's no entitlement to fees to be paid by the prevailing party. They can make that proposal, and they can work that out in the proposal. So the offeree, the individual litigant, is going to get the $10,000, and the proposal will say, and we're going to give your lawyers $50,000. So it's a $60,000 offer of judgment, specifically outlining who gets what amount. So I think they can work around those issues. And that gets to the ultimate goal of resolving the cases early, in the cases that should settle. Justice Lawson, you were asking questions about the joint proposal. That's an interesting rule, because this is a brand new rule, right? The Supreme Court's proposal to create C5 is a brand new rule, and our committee studied the Gorka, and we've sort of interpreted the Supreme Court's proposal that we're here to talk about as being essentially what the dissent was proposing in Gorka. Chief Justice Kennedy, right? I mean, I think that's right, but I do think, Justice Lawson, there's a way to do it, and that's what we proposed. What we proposed is take that construct, but make it apply only to particular types of cases where it really is workable. Current C4 in the rule applies to cases where there's undifferentiated damages, cases where those parties are going to be aligned, and what we've proposed, consistent with the Gorka dissent approach, is to make the offer available to those types of claims, allow an offeror to make it conditioned on mutual acceptance, and if one party accepts and the others don't, that one party is excused or will not be subject to the sanctions available under 768-79. That was the committee's best effort in this amount of time to come up with a workable rule and avoid, like we said, there are going to be games. Litigants will likely try to come up with more creative ways to do that.
Well, at the end of the day, whoever loses is going to litigate. I mean, that's just a reality of where we are, right? If you lose one of these rule statutory issues, then whoever loses is going to litigate. I think the purpose, at least as far as I'm concerned, of having these rules proposed is to eliminate the magnitude and the body of law out there that could possibly be litigated, and to try to eliminate some of that. I agree with Justice Warga that this is broke. The law in this area is a mess. It's an absolute mess from my perspective. And so I, for one, would like to see some change made to try to make it workable and to try to encourage settlements. So that's the purpose, at least, from my perspective.
Right, and I think that's a fair point, Justice Paulson. I think you're right. Whoever loses on the proposal for settlement process is going to litigate it because of what's at stake, whether, for the fees or potential malpractice claims. Right?
Can I ask you, I'm sorry.
Yes, sir.
So, and I don't know if you were just trying to be diplomatic in your filing, but is it your position that on this issue, on the joint proposal, that that the proposed rule actually conflicts with our court's substantive interpretation of the law? To the extent that it seems like the majority's position in Gorka, and they kept bouncing back and forth between the statute and the rule, but one way of reading Gorka is to say that the statute itself requires, offers that can be accepted individually. And it seemed like you came close to saying that what we've proposed would conflict with that substantively, but I just wanted to see if you wanted to clarify that.
Well, yes, we were being diplomatic, but we were also being, it's accurate. I mean, I think the way that I understand our comment on this issue is this court's proposal, it really does seem to be an adoption of Gorka's dissent, which would by default be an abrogation of the rule in Gorka. Meaning Gorka said you can't make an offer of judgment or proposal for settlement conditioned on mutual acceptance because there's no opportunity to independently evaluate for each offeree what you're accepting.
And you view that as an interpretation of the statute? Because obviously if Gorka is read as just being limited to interpreting the rule, then this rule could change that. But if it's an interpretation of the statute, then that's a separate question.
Our committee didn't see this as an issue outside the purview of the court to do, meaning that it's not substantive, it's procedural. We didn't take a position whether Gorka got it right or wrong. Well, all we said was Gorka majority controls. And so if you adopt...
But I think the question is, isn't Gorka interpreting not just the rule, but also the statute?
Oh, absolutely. I'm sorry. Yeah, no, it is interpreting the statute. That's
And
right.
to the extent that it did, then arguably we can't use a rule to override a substantive interpretation of a statute.
That would be correct. We didn't take a position on that. The committee, subcommittees, we didn't evaluate that at that level. We do think that this court, consistent with Gorka, could make the rule. We just think that adopting the current rule would...
Let me ask you this, counsel. This is kind of stepping back from all this. Given the way all these things interact, all the complexities, the questions about what's substantive, what's procedural, couldn't a case be made for it being time for the legislature to look at this and address these questions and try to come up with changes that would address the problems that have arisen, and then they can, substance is their arena, and they can make the substantive choices, and they can listen to people who come in with their different perspectives. So what do you say about that as being a really a more effective way to solve whatever problems, some of which are substantive, that exist in this arena?
If we had a magic button and we could ensure the legislature would get that on, absolutely, Chief Justice. But we're working with the rules that we have, and so I'm also involved with the COVID-19 task force, and we know that there's the work groups on judicial resolution and improved resolution of cases. Our courts are in a problem right now. They're suffering. The trial courts are backlogged now more than they were 2 years ago because of COVID. If we wait till the legislature,
Maybe they do better. Maybe something we hadn't thought of, any of us.
no, I think they might, and I think they should, and I certainly think that's an appropriate vehicle. But for right now, we as the Rules Committee believe we should work with the rule we have, and in response to this court's proposal to make the amendments it made, we just provided our response and our comments to try to align them with that purpose, with that function. As a practical matter, and this is why I raised the committee's composition on the front end. We have lawyers and judges from all walks, from all areas of practice. And I think the consensus is you need this vehicle. You need proposals for settlement. They can be effective if they can be used in a manner that are going to be used. As a practical matter, if you don't include non-monetary terms, which was something the committee felt strongly should remain in the rule, as a practical matter, a lot of defendants are not going to use them.
Well, you mentioned the liens, right? Let me ask you just, if you got a judgment, if the plaintiff got a judgment, and the judgment was to be satisfied, talking about the rules, set aside the rule for a minute, right, the settlement issue. If the judgment was there, and the check is to be cut in satisfaction of the judgment, how does that check get cut? Who's it made out to? Is it made to the plaintiff only, or is it made to the plaintiff's lawyer, any preceding law firms, and any non-lien holders? All included in the name of the check. How's that transmitted?
That's a great question. Unfortunately, I don't know the answer to that specific. I haven't seen a lot of checks cut at the end of the litigation, but I think, as I understand it from our discussions at the committee, Justice Polston, is when there's a check cut for a case that might have medical liens and issues of that sort, there is still a recourse against the payor of that check if there are unpaid liens. And those are concerns that were raised by the committee, the subcommittee, and those non-monetary conditions.
So all that is a matter of substantive law, is it not?
The effect of why you would need the non-monetary condition, in other words, yes.
And what does the check say, and when does the judgment get satisfied? All that's a matter of substantive law, not procedure.
Well, I think the same can be said for rules about the form of pleadings and service of process, right? Our procedural rules are going to necessarily
But whether a
affect.
judgment is satisfied by a check that's cut in a certain way and who's on it, I think the liens and how that gets satisfied, and whether or not how you actually pay that, whether it be by settlement or in satisfaction of a judgment, how that gets done, it seems to be a matter of substantive law. So the issue on non-monetary items, the release and all those different things seems more substantive than it does procedural.
And I see I have about 8 minutes left.
You can keep going.
Thank you, Chief Justice. What I would say is this: 768-79 does not expressly, it doesn't mention non-monetary terms. It's just silent as the non-monetary terms. So starting with that, there's no conflict with a rule as an initial matter because it's silent. The statute is silent on that front. And just like in the White versus Steak and Ale case, when the majority had to define judgment obtained, and they looked at the purpose and function of the rule, we would suggest that that's an appropriate approach here. Look at the purpose and function of the rule. These proposals for settlement, whether it's dealing with the lien issue on the non-monetary terms or a release, these are the sorts of guarantees that the defendants and the offerors, in practice, in reality, litigating every day, are going to want to get in many cases. And so if not having that ability, which shouldn't, it doesn't cost the plaintiff anymore. We agree there's a whole line of cases that talk about don't ask for a general release that asks the offeree to give up something outside of what's at stake in the litigation. There's a ton of cases that talk about that. What we're talking about is resolving what's at stake here, whether it's the medical lien issue and a release as to these claims. That's important as a practical matter. That would be consistent with the function and purpose of the statute, and the committee felt strongly that not having that a tool available to litigants would make the proposal for settlements less likely to be used.
One big one is confidentiality agreements that a
Agreed.
lot of people request. Would that be considered substantive?
I mean, there could be substantive components to what the confidentiality agreement could or could not permit, but the inclusion of it as a non-monetary term, the committee feels that it is not substantive because it's not creating a right or a rule that's inconsistent with the statute. The statute is just silent on it. It's a tool to get to that end game, which is get the cases settled.
We'll now proceed to the second case on today's docket, Velasco versus the state.
Good morning, Chief Justice, and good morning, Justices. It is a pleasure to be here before the court today. My name is Michael Meyer, and I represent the petitioner, Mr. Velasco, in this case. Mr. Velasco was convicted in the trial court of 3 different charges. Count 1 was leaving the scene of an accident involving serious bodily injury. Count 2 was DUI with serious bodily injury. And count 3 was DUI with property damage. The issue framed before this court is really about the counts of DUI with serious bodily injury and DUI with property damage. And the reason that this comes before this court is because there is a conflict in the districts. We appeared before the 3rd District Court of Appeal. The 3rd District Court of Appeal felt that the DUI with property damage was an offense that was not double jeopardy with respect to the DUI with serious bodily injury. The court in the 4th DCA, the Anguille Court felt that that particular offense, DUI with property damage, was in fact a degree variant of the DUI statute.
Counsel, can you direct us to any place in our statutes where damage to a property, a piece of property, chattel, and damage to a person are differences of degree variance, and not different injuries in kind, anywhere other than the DUI statute? So consider arson, robbery. Is there anywhere else in the statute where you get an outcome like the one you're advocating in this court?
Judge, I'm not familiar with any other statutes that do require or do separate there's a distinction between chattel and or a person.
As degree variants of each other.
As a degree variance of each other.
So why should we say that in this case, injury to property can somehow be subsumed in injury to a person, where obviously injury to property is not an element in establishing injury to a person?
When the court looks at the DUI statute 316.193, it specifically, first of all, the elements of a DUI are simply that an individual is driving a vehicle or in actual physical control. The second element is that they were under the influence of either a controlled substance and or their breath or blood alcohol was greater than 0.08. We then go down to subsection 2, which creates the aggravators, if you will, of the DUI statute. And when the DUI statute specifically talks about whether it is damage to a person or property of another. So it specifically includes damage to a person and or property of another. And when the court looks at 316.193 and goes through the statute, it essentially is a degree of variance that would, in a sense, enhance the penalties depending upon the harm that was caused. And if the court looks at the statute, it specifically talks about a DUI, a simple DUI, punishable by 6 months in the county jail. DUI to property or a person, punishable by a year in jail. DUI, serious bodily injury, punishable by 5 years in prison. DUI that causes the death of a person or an unborn child, 15 years in state prison. And so there's a degree variant that I believe the statute itself is set up in such a way that it is not, when the court looks at the Blockberger test, and obviously the justices know that the Blockberger test has been codified.
So if I'm hearing your answer to my question right, what you're saying is the statute tells us that these are degree variants because they're escalating penalties. But that can't really be the answer, because they're often escalating penalties if they're offenses that have different elements have different impacts that the legislature has decided to treat differently. Consider the following. Imagine that there is an accident and the owner of the vehicle sustains serious bodily injury, broken femur. But the vehicle is a limited edition car, a 1952 Gullwing Mercedes worth $2 million. Your reading of the statute would say that victim is out of luck in terms of recovering anything for the damage to his property if, from a restitution standpoint, and the state is out of luck from the standpoint of prosecuting that as a crime against property, if instead the state elects to put the defendant in jeopardy of having caused serious physical injury to this person. Am I right, or am I missing something?
Well, I don't think you're missing something, but I think we're not. I think the law is clear that we don't look to the accusatory pleading, and in the statute itself, it specifically says damage to the property or person. And what we have in this case is, unfortunately, Mr. Rodas, who was in fact the owner of the scooter that was injured, he was also injured himself. But the statute specifically says, and I think if the legislative intent was that that should be a separate penalty, if you will, or a separate crime, I certainly don't think that the legislature would have written the statute to include property to a person or property of another. And that's where I believe the degree variant comes into play.
I'm sorry to interrupt you. Can I ask you a question about that? Because I know you're not proceeding under 4A, but it seems like we could avoid all the degree variant stuff if we just looked at 4A, and it says that their offenses are separate if each offense requires proof of an element that the other does not. And it seems like since this is written as property damage or bodily injury, and it tells us, the statute tells us that we're not supposed to look at the facts of the case or the proof adduced or the accusatory pleading, that it doesn't require it because it could be proven either way. And it seems like, I guess you've waived that, and we couldn't reverse the third district on that ground. But as far as just our overall jurisprudence, I'm wondering why relying on 4A isn't the more straightforward way of getting to the right answer here.
Well, again, I don't think that the injury is an element of the crime. I think it's an aggravator of the crime. So I think that the elements of the crime are set out in 316.193 subsection 1, and it goes on to say that the penalties you refer to subsection 2 of the DUI statute. So the point being is that it is, from our view, these are all aggravating factors that step up in degree based upon whatever is adduced at trial. And without looking to the accusatory pleading, it does become a degree variant of the actual DUI itself. In other words, if you have a DUI and it's your second DUI, the elements are going to be the same. The punishment is going to be greater because there's an aggravator, if you will. Or if it's a third DUI, or a fourth DUI, it could be a third and subsequent conviction. It could be a felony.
But as far as what we're comparing, I thought that this whole thing has been litigated as if the two things that are being compared are treating, the one crime of the serious bodily injury with that as an element, and then looking at the property damage / regular bodily injury, is that those are the two things that are being compared, not that there's just sort of one crime, i.e. DUI, with these different aggravators. I mean, I thought the whole logic of this was that the comparison point are those two things.
Judge Munoz, for example, if someone is convicted of a DUI with personal injury, we know that they cannot also be convicted of DUI with serious bodily injury. And the statute that refers to personal injury is the same statute that deals with property. It's the same part of the statute, because it says property or person.
Right, I mean, that's what I'm saying. It seems like that's why I don't understand why you didn't rely on 4A. And then that way you don't have to get into the degree variant thing.
I understand. I understand what the court is suggesting, but from when the court looks at the Blockberger codification, we believe it's the second prong of the codification, which deals with it's a degree of the same offense as provided by the statute. It just, and I think another potential example is, although a battery on a police officer or a simple battery. So it's an unlawful touching of somebody, and it just gets elevated because of the touching to, say, a law enforcement officer or a firefighter. The penalty becomes aggravated because of the nature of the offense, and you have to look to the accusatory pleading. But it's a degree variant of the same crime. So you can't be convicted of both. You couldn't be convicted of both battery on a police officer and simple battery. Just like you couldn't be convicted of driving with a suspended license and driving as a habitual traffic offender. I think those are both degree variants of themselves. So we're asking the court to rely upon the Angeli.
Counsel, can I
Yes.
ask a question? In Justice Coriel's hypothetical, nothing would preclude restitution from being required for all the damage resulting from the DUI, correct?
I think the restitution statute is very broad, and so it's restitution to the person and whatever resulted from the crime. I think that's probably fair.
And in just a slightly different set of facts, if, let's say, the person committing the DUI ran into a person on the sidewalk in front of their house, and so you had an injury, but then they also ran into the mailbox that belonged to the same person, would you change your view of this in any way? So it's not necessarily the person was in the car or on the scooter, as
Right.
we have here, but still one victim, but two kind of separate instances of damage. Would that change it at all for you?
Your Honor, I don't believe so. I think that it is still, it's the person or property of another. It's not a separate victim. There is many cases out there that involve multiple victims, which is not the case here. We have a situation where it is the same victim. So in that scenario where you have a mailbox that belonged to the victim, maybe he can, I think you're right with the restitution. I just don't, I think that double jeopardy, Blockberger, and the codification precludes the prosecution, if you will, of the property.
But in this case, if the scooter had been jointly owned,
Right.
there could have been two charges under your analysis.
If the scooter was jointly owned and there was a separate victim, I think you're correct. I think you're correct. I think then it is not necessarily degree variant because there's a separate victim, and so I would agree with that proposition. I would agree with that proposition. If I may, I'd like to pivot to an issue that was briefed, and that deals with the confrontation clause. In this particular case,
Isn't that the more significant issue for your client?
Chief Judge, it is the most significant issue for my client.
the other one's like...
It is the
not
most
much
significant
of an
issue.
impact.
In this case, we have no issues with the trial court granting the motion for the perpetuation of testimony. That's not the issue before this court. The issue before this court is what we believed was an abuse of discretion in determining whether or not a witness was unavailable on the day of trial. And simply, the record does not, in our humble opinion, prove by a preponderance of the evidence, which is the standard. The standard is that the trial court must find, by the preponderance of the evidence, that the witness was in fact unavailable on the day of trial. And if the court looks to the transcript of the day of when the trial proceeded, there was an assistant state attorney who stood before the court and said, well, she's had surgery 3 weeks prior. She was in and out of the hospital. And I spoke to her this morning, and she said that she was sick, and she was on steroids. There's nothing, the record's void of what does sick mean? Did she have a cold? Did she not feel well?
The trial court, though, in dealing with this, makes several findings, right, about her past surgery, her future surgery. On that record, how is it how can we say that no reasonable trial judge would have disagreed with you? How are we able to say that there's an abuse of discretion where there are these judicial reasons for the outcome?
Judge, I think previous surgeries was one of the reasons that they perpetuated the testimony and that she was on dialysis 3 days a week. But really the issue is unavailability on the day of trial. It's not, I had surgery 3 weeks ago and I couldn't possibly have been available 3 weeks ago. The issue is the confrontation clause and my client's ability to confront a witness in court when she's the linchpin to the case, and there is nothing to suggest, other than she had surgery 3 weeks ago.
Well, the judge does say something about future surgery. I'm hearing a very persuasive argument about why the trial court got this wrong. I'm not hearing a very persuasive argument about why the trial court abused its discretion, which is different. Can you make that argument?
Your Honor, I think that the analysis that Judge Miranda had made at the trial court level, talking about things that happened to this witness previously, does not address the issue of whether or not she could be procured as a witness today. I mean, that's really the issue that we have to deal with today. What is wrong with her today? Why can she not come to court today? Forget about that. I mean, there's plenty of scenarios where someone has surgery and they recover.
Let me ask you, because having served in the trial court for 13 years, I dealt with this constantly. People get sick. Take a situation that I've had, not just me personally, I did, but a witness, cancer. And the person is taking chemotherapy. And anyone who's gone through that will tell you that you're going to have good days, you're going to have horrible days. State Attorney's Office, I was once one, they have witness coordinators. It's not the prosecutor who's calling the witness, it's a coordinator who's delivering the witnesses. And they call these witnesses. And I think what you're suggesting is that the judge should have asked the question, well, how does she feel today when she's going to testify? And because she could have been having a good day that day, and she might have said, I feel fine. If you just send somebody over to pick me up and take me over there, I'll come in and testify. Whereas the next day she may have taken a turn for the worse. So it's not a question of having all these conditions that may lead to a person not feeling well. It's how the person feels on the day that the person's testimony is required. I think that's what you're saying.
Judge LaBarga, that's exactly my position, because listen, health can wane, and some days could be good, some days could be bad. This woman apparently had some issues, but the issue, yes, before that trial court judge was whether or not she could have been procured to come in that day, and what was wrong with her. And the record's void of that. And when you have a witness who's the only real witness to this case, that's the part that is most troubling, and that's the part that I believe the court should and had a duty to do more for my client's right to confront that witness in court.
Counsel, you have used up almost all of your rebuttal time. Now, we helped you with that, so you've got 30 seconds left, but I will afford you 3 minutes anyway.
Thank you, sir. If the court has no further questions, thank you.
Thanks. Oh, no, go ahead.
So could I take you back to the first issue?
Yes, sir.
And sort of building on Justice Coriel's question. So we have these statements in our prior cases where we say that, we don't need to see the magic word degree. And then it says there are other statutory designations that can evince a relationship of degree. For example, when a crime may have aggravated forms of the same basic offense. So if we were to adopt that as kind of the, our interpretation of degree variance, why wouldn't one way of looking at this is that, the same quote unquote basic offense would be, causing injury to a person versus then an aggravated form would be serious bodily injury. But that when you're talking about the property damage, then you're no longer really talking about the same quote unquote basic offense.
I think it is, Judge Munoz, I believe it is the same offense, because when the court looks at that statute, the statute progressively gets more difficult. The penalties become harsher. It's an aggravator for every time you go down through that statute. It's almost like the grand theft statute, even though it doesn't say degree. But when you talk about the grand theft statute, if it's more than I know they just changed it, but if it's more than $1,000, then it becomes a felony. If it's under the $1,000, it's a petty theft. If it's more than $10,000.
And I think Justice Coriol's point was that in an example like that, you're just talking about the same type of harm, and you're just, the more of that type of harm that you create, the more culpable you are, the greater the punishment. But here we've introduced sort of a different category of harm. And so to apply this definition, it seems like for this definition to apply to you, the basic offense has to be DUI. But if we say that the quote unquote basic offense is DUI that causes physical harm to someone, then maybe you see the degree variant relationship, but not if you consider this property damage to be kind of a separate type of offense. You're no longer talking about the same basic offense. And I guess once we get away from sort of the literal kind of looking for a degree relationship explicitly laid out in the statute, it seems like it's not obvious how you define what the quote unquote basic offense is.
I think what you're suggesting is that it's an element, a separate element, so therefore it would not violate Blockberger. I think if that's what I understand the court to mean. But from our perspective and my review of the statute and my reading of the statute, I believe the Angeli court got it right, and I believe Judge Emis in his dissent got it right, which was very eloquently written.
Okay.
Thank you.
All right. And counsel, I still will give you 3 minutes for rebuttal.
Thank you, Judge.
May it please the court, my name is Ksenia Smuchkuskaya, Assistant Attorney General, appearing on behalf of the state of Florida. Petitioner convictions do not violate double jeopardy. DUI, property damage, and DUI, serious bodily injury, are not degree variants. In making determination as to whether these two offenses are degree variants, this court should look at the text of the statute, the statutory scheme, and how differently does the statute treat bodily injury and property damage. The statute classifies DUI property damage as a misdemeanor, and it only includes, in that subsection 3C1, regardless of the value of the property damaged. In other words, regardless of whether a defendant hits a scooter or a Maserati with Mona Lisa in it, he can only be charged under that DUI property damage provision. There's no greater or lesser value of the property damage in the statutory language. Then if we look at the DUI serious bodily injury, again, there's no serious property damage language in it.
Can I ask you to turn to the discussion that we've been having, Justice Grosshans and I were having about restitution for a moment. So you say the Maserati with the Mona Lisa in it. All right, so let's say I'm driving my Maserati, I happen to have the Mona Lisa in the back seat. I'm in an accident, I break my femur. But I've suffered restitutable financial harm. The answer we got from co-counsel, from your opposing counsel, was there's no prohibition on your seeking restitution or the victim as the state. Can you respond to that? Because it would seem like that's a very strong argument for trying to read the statute in a way that makes the property damage a degree variant, right? Like if that harm is still remedied by restitution, then do you agree that that helps opposing counsel? And if so, how do you respond?
Okay, so if the driver is the one who's sustaining property damage, the driver cannot be charged under that provision because it's property damage of another's property. So the driver, if the driver is the one whose property is damaged, cannot be charged and recover himself. So it's another person who would be able
But
to
counsel, I
recover.
think what we're asking is if the driver hit a car that injured the other person and also injured the Maserati with the Mona Lisa, and you charge serious bodily injury, would you still, as the state, be able to seek restitution for the Maserati, Mona Lisa, and the medical restitution all?
Under the restitution statute right now, yes.
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 And I have a question for you. Under the state's theory, would you be able to charge as two separate offenses, DUI with property damage and DUI with bodily injury? Not serious bodily injury, just under that same subsection.
Because it's an alternative statute, I believe so. So it would be just one charge, just based on not two counts.
You could not bring, so if the person was moderately injured and did not rise to the level of serious bodily injury, it's the state's position that you could only bring one charge, property damage or injury to a person, damage to a person.
Because it's an alternative statute, and if it's the same victim, I believe the reading of the alternative statute will allow the state to charge only as one count. However, this is not what we have here for. We do have a quite different charges, which is DUI property damage and DUI serious bodily injury. There are two different subsections, two different statutes, which petition does not dispute past the Block-Berger test as separate offenses, and legislature does allow the state to charge and convict for two separate offenses. So that's quite different from the hypothetical. Then
in Valdez, the court defined it, because they said it doesn't have to say the magic word degree. And then they defined a degree as a level based on the seriousness of the offense. And that's how Valdez said this is how we determine if these are degrees. What is your best argument that that's not what we have in the DUI statute, that we do not have different levels based on the seriousness of the offense?
it is state's position that there are two very different, distinct type of harms that don't overlap. How do we compare property damage and serious bodily injury? Because those two result in incomparable type of harms. They're not even aggregated forms of one another, because serious bodily injury is not an aggregated form of a property damage. And then also in Valdez, this court did held that there was a legislature intent to disallow separate punishments for crimes arising out of the same transaction only when the statute itself provided for degrees with multiple offenses. In other words, when the statute expressly classified them as such. And in this case, the legislature chose not to classify the DUI-related crimes by degrees. And it's if not dispositive, it's a crucial factor.
You know, that seems to be kind of a highly formalistic view of it, because if you just look at the way this is structured, you've got the offense of DUI, and then you have these escalating penalties based on particular harms associated with the offense. Different degrees are referred to. It starts with a misdemeanor of the first degree, it goes to a felony of the third degree, and then felony of the second degree, and then a felony of the first degree. So that's just part of the structure here. Now, there's no question that if the legislature wanted to punish these different harms as distinct offenses, they could do that. But I just don't, I'm having a hard time seeing how in the structure, the formal structure of this particular statute, we would conclude that they have done that, as opposed to defining this DUI offense and then saying, okay, we've got these aggravating circumstances which will affect the level of punishment that will be imposed for the DUI offense.
Right, but also, well, if we look at the DUI property damage and the penalty that it's imposed, and then we go down, there's no DUI serious property damage. So for DUI property damage, there's no enhanced penalty going down. The only penalty for DUI property is that classification is a misdemeanor, and the penalty according to that classification. So for DUI property, there's no enhanced penalty if we go down. So with this being said, there's only one DUI property damage in the statute.
Well, the statute is what the statute is.
Right, so although it's important to see how the legislature structured the statute in terms of the penalty increase, it's still not necessarily a dispositive factor when it comes to determination whether the 2 degrees fall under a degree variant exception. And I would also like to address the point that petitioner made regarding the prohibition to look at the accusatory pleading, because the only harm pled in this case was DUI property damage, not DUI personal injury. And if we look at the subsection 4A Block-Berger test, the limiting language is included only in subsection A. Specifically, the statute says, for the purpose of this subsection, offenses are separate if each offense requires proof of an element that the other does not, without regard to the accessory pleading. So the limiting language is included only in Block-Berger statute. Then if we look at the subsection 4B, let's call it exception statute, there's no such limitation there. With this being said, it is relevant to look at the pleading and see what the actual charge is in the alternative statute, which is, again, the only harm pled here is property damage. And based on that,
No, I'm confused. How do you get the conviction for the bodily injury?
For regular personal injury?
Right.
If it's charged, Your Honor. So here we don't have DUI bodily injury. So to determine whether the degree variant exception applies, if there's alternative statute as here, there's no express prohibition and the exception statute that we cannot look and see which one is charged to determine the relationship between the two. The prohibition language is included only subsection 4A. The Block-Berger test, this is where we take the whole alternative statute and both conducts.
I'm sorry, I think I'm misunderstanding you, because it says here that the defendant was charged with both DUI, serious bodily injury, and DUI property damage.
That's correct.
Okay.
Petitioner made a point that under the misdemeanor statute, there's alternative language, DUI property damage or damage to person. And petitioner made an argument that we cannot sever them both, and we must, for degree variant purpose analysis, to compare the entire range of conduct. So it is the state's position is that when we apply Block-Berger test, yes, indeed, we have to consider the entire range of conduct, and we prohibit it by express language of the statute to sever them and look at the accusatory pleading. However, when we're trying to determine whether there's a degree variant exception, in particular this case, because there's alternative conduct, the information becomes relevant. And here it is relevant because the only harm pled under the misdemeanor is DUI property damage. And comparing DUI property damage and DUI serious bodily injury, those two are not degree variance, and therefore there's no double jeopardy violation.
I have a question. Hypothetically, if the legislature had chosen to simply have injury to a person and had skipped, not included property damage, and then great injury to a person, would you then view this as a degree variant?
Your Honor, perhaps, because both of them would, they would not even pass probably Block-Berger test. So we would be at the subsection A. If there's no property damage pled, and there's a, for example, broken finger and broken femur.
I'm not talking about subsection A. I'm talking about the degree variant. I believe it's subsection C in our case law that interprets what that means. So what would be your argument that it was not a degree variant statute if property damage wasn't included in that particular degree?
So it would be the charge under the same statute, however, the only pled harm would be personal injury and then serious bodily injury in your hypothetical, Justice Lawson?
Yeah.
Again, we would, under those facts, perhaps that would have been a stronger claim of degree variant relationship.
Is it the state's, I'm sorry, go ahead.
And I'm wondering really sort of why that makes a difference. If it meets the test for a degree variant statute, the fact that the legislature chose alternative conduct, and I'm thinking about the aggravated battery statute, which makes a crime an aggravated battery if there is serious bodily injury or use of a deadly weapon. Okay? So if we're talking about a different crime, that crime, you couldn't charge somebody with 2 counts of aggravated battery if they used a weapon and caused serious bodily harm, correct? That would violate double jeopardy.
Correct.
If it was an alternative conduct statute.
Correct.
So, I mean, if that's true, the fact that they included an alternative conduct in this scheme, I'm just, under subsection C, determining whether it's a degree variant statute, it seems almost like a red herring. I mean, it's laid out like a degree variant statute. Judge Emis did a really good job of explaining why it fits our definition. Why should it matter at all if, just looking at the degree variant portion, that there's that alternative conduct that's different?
Well, because in our particular statute, the property damage is such a different and distinct type of harm that was caused. And this is exactly why a respondent does argue that looking at the actual pleading for the purposes of the analysis of the degree variance is relevant when it comes to alternative statute.
So if I'm hearing you right, what your answer is to Justice Lawson's question is, it's really not alternative conduct, it's alternative harm.
That is correct. It's definitely a crucial point.
Okay, so I guess my question then is, and it's a similar question to the question I asked opposing counsel. Where else in the statutes can you point us for evidence of your position? That is, are there other statutes where the degree variants are degrees of the same kind of harm, right? It seems to me that when we speak of degree variance, we're talking about things that can be measured on the same gradient. So in a property crime, the value of the property is susceptible to that kind of degree measurement. Whereas different harms are different in kind and not in degree. And so I can't really say, other than say the cost of medical care, some like remedy at law, that the harm suffered by the person with a broken neck is of some comparable degree to the person who lost 100,000, 200, 500. Like, that's not a degree that is susceptible to measurement. And degree, I think the nature of the word, includes some susceptibility to mutual comparison. So my question is, help us look at other, and I wish the briefing had done this, other areas of our statute that do address degree variance along the same gradient: arson, battery, robbery. Are there any other statutes that support your position in that they bifurcate whether or not there's been a criminal act based on the kind of harm?
Well, Your Honor, I think the respondent response would be the statute that somewhat support respondent's position. The theft statute, it not only has a classification by degree, but also value. Here we have no assigned value.
Well, but isn't it true that the legislature has assigned value? They've decided certain types of harm are worthy of a higher penalty, and they go through it very systematically, and they describe the type of harm and the associated penalty. It escalates.
It
and
does,
so
yeah.
they are making a judgment about the quote unquote value of the harm that's been done and the penalty that should be imposed accordingly. And isn't that just part of the structure of this statute?
That is correct. It's definitely a factor in considering the relationship. However, it's the respondent's position that it's not a dispositive factor when analyzing degree variance relationship and the exception application.
So it seems like your answer to Justice Grosshands' question about someone being charged for, non-serious bodily harm and property damage, it seems like the whole logic of your argument is that they can be severed, and that you would say that it is a degree variant, as Justice Lawson was asking, if you're comparing non-serious bodily injury to serious, but once you introduce property damage, you're talking about a whole different category. So, but by you conceding that you couldn't be charged for both property damage and non-serious bodily harm, it seems like you're conceding, as the Chief is suggesting, that really that's just one thing, one crime that is then sort of, at a lower level than, the serious bodily harm. So can you help us understand that?
I think what the respondent position is that the actual charge matters. And when we decide whether there's a degree variance relationship between the two charges, this is when the alternative statute and severance in those matters.
But it seems like, though, this statute is set up in a way that we're looking at you look at the face of the statute, not what was pled or proven.
So that's the other point that respondent was making. If we look at the subsection 4B, there's no such a mandate or prohibition to look at the actual charge.
Well, but in the statute, the part we're operating under, I'm talking about 775.021 4B, 2,
Yes.
offenses which are degrees of the same offense as provided by statute. I just don't see how the way it's charged. This is about analyzing the statute, it seems to me. Yeah, that's the way that would be understood. Just based on that language, offenses which are degrees of the same offense as provided by statute.
But the same reading of the provision and with combination with this court's opinion in Valdez, it means if statute explicitly defines offenses by degree, so as provided by statute, explicitly provided by statute, these offenses are not classified by degrees. And that's the main position that the state is taking. Again, the penalty structure is not included in this particular statute. It says just as provided by statute. And that language was interpreted by this court as explicitly classification by degree. Then there's a language in recent opinions whether they're aggravated forms of one another. And respondents' answer to that is that they are two distinct type of harms and they're not aggravated forms of one another. And therefore, they're not degree variance, and there's no double jeopardy violation.
And I know that you're out of time, but just to be clear, you do agree that if hypothetically the victim had been scraped, so it wasn't serious bodily harm, and the scooter had been scratched so that there was property damage, you could not get a conviction for two convictions, DUI with property damage and DUI with injury. You agree that that would be prohibited by double jeopardy?
Your Honor, it would be just one charge for misdemeanor based on that statute.
Okay.
And I know I'm out of time. May I briefly
Well, yeah,
conclude?
I'm going to give you a little extra time because I'm giving the other side a little extra time. So you can keep going for about a minute and a half more.
Thank you, Honor. Just briefly to address the second point that petitioner addressed. The trial court did not abuse its discretion when allowed the introduction of the witness's testimony. The record is clear that the witness was not available for trial. She had a tumor extraction surgery just a few weeks prior to trial. She was going to dialysis 3 times a week. She had ongoing health issues. She had complications. She had upcoming surgery just a week away from trial. The record also reflects that the trial court was very familiar with the medical history, medical condition of that witness. And in fact, the defense counsel did not dispute the physical condition, then existing physical condition of that witness at trial. Based on that, there was no reversible error. And if this court doesn't have any further questions, the state would respectfully ask that this court finds there was no double jeopardy violations, the offenses in questions are not degree variance, and approve the 3rd District decision. Thank you.
Thank you, counsel. Rebuttal.
Thank you, Judge, and thank you for allowing me additional time. Judge Curio, while I was listening, I thought of a couple scenarios that I think answer the court's question, is there any other statute? I think leaving the scene of an accident addresses that exact issue, because I don't think that's a degree, it's not explicit in the statute that they're degrees, but I think it's very similar to the DUI statute, which is leaving the scene of an accident involving just property damage is a misdemeanor. Leaving the scene of an accident involving injury, misdemeanor. Serious bodily injury, felony. So I think this is the same analogous as to the DUI statute, because it involves just the harm. You know, the crime is leaving the scene of the accident without rendering aid or providing your information, and then you have the aggravation, if you will, as to what was the cause. And I think that's a similar issue, and I think that driving with a suspended license statute also dovetails into that as well, because you have, again, it's not degrees of the crime, but it certainly is aggravation factors if someone's injured as a result of driving with a suspended license. I also would like to bring up the point where the Valdez court, this court in the Valdez decision specifically said that it does not need to expressly say that it's a degree. And when the court looks at the DUI statute, the language itself, the framework evinces a degree of relationship, providing graduated imprisonment sentences based upon the harm that resulted from the particular conduct of the defendant.
So how would it affect your case if the legislature had chosen, instead of writing it the way they did in the alternative, damage to the property or person or another is a misdemeanor, if they had said damage to the property of another is a misdemeanor, and then in a separate sub-paragraph or whatever it would be, damage to the, so one said damage to the property and the other one said damage to the person is a misdemeanor, would that change? Because then you could really see that the degree variance relate to the personal injury, but that, you know, arguably property would be in a completely separate category that wouldn't necessarily as intuitively fit into the degree variant concept.
I think it would fit in less, but I do believe that it's still a variant of the harm that was caused by the underlying DUI. So I do believe that it would still be a degree variant of the actual DUI, because it's the same victim. That would be the point.
And if the statute were written such that they were separate kind of subsections or whatever, could the person be charged for both property damage and damage to the person that's
Well,
not serious bodily injury?
Judge Munoz, I think anybody could be charged. The question is,
Well, could they be lawfully convicted of both?
I think it would be precluded by Blockberger in the codification of the Florida statute based upon
But
that.
counsel, I mean, there's a way the legislature could separately punish these harms. You would admit that.
Of course, sure. Yeah, I think they certainly could if they were to rewrite the statute, but I think the statute as written is a
And
degree.
perhaps I misunderstood the question, but I think the question suggested a structural change in the statute.
Yeah, if there was a structural change and it wasn't just a variant based upon harm, sure. But what we have here, I think, falls under
So
double
it seems
jeopardy.
though like we're trying to choose between which hyper-formalism we want to be. Do we want to look at the, non-use of the magic word degree, or do we want to rely on the fact that they lumped them together in the alternative? Because it seems like, to the way everybody's been talking about this, it might really make a big difference if they had separated the two into different sections.
I still believe, but even if you separate it, just like they did with bodily injury, they separate injury, serious bodily injury, it's still separate. And in our position, it's still a degree variant of the same harm.
I don't think anybody disputes that if you take the property damage out and there were a statute that said, it's a misdemeanor to harm someone's person, and it's a third-degree felony to cause serious bodily harm, I think everybody would agree that those are degree variants.
I think the trigger word, Judge, is the property or injury to another. And so I think when you look at the language of the statute and it says another, I think that is the legislative intent that if it's one victim, it's one crime. That's our position.
All right, counsel.
Thank you.
Thank you, counsel. We thank both of you for
Thank you very much.
arguments in this case today. And that concludes today's docket, so the court will now stand in recess.
All rise.